I'll now call the second case on this evening's docket. That is case number 119278, GFT Lenexa LLC, v. City of Lenexa, Kansas.
Chief Justice Nuss, may it please the court, Luman Mulligan on behalf of GFT Lenexa, respectfully request 3 minutes for rebuttal.
3 minutes is granted.
Thank you, Your Honor. The city condemned real property without giving GFT its statutorily required notice, nor did it join GFT to the original condemnation proceeding below as required by statute. After suffering a loss to its rental income, GFT brought this inverse condemnation action. On cross motions for summary judgment below, the district court found on uncontested facts that GFT makes a prima facie case for inverse condemnation. Nevertheless, the court below found that the underlying ground lease bars GFT from pursuing damages in this matter. That was error. I have 2 arguments this evening for reversal and remand. First, under Kansas law, on plain language of the contract and 4 corners of the document approach to interpreting contracts, the district court erred. Second, GFT was barred under this court's opinion and Bullard from intervening in the original condemnation action. To my first argument.
Well, why don't you start with how is this an inverse condemnation case? When I've searched all the cases having to deal with inverse condemnation, it seems to me what is required is that action is available when private property has actually been taken for public use without the initiation of a formal condemnation procedure by a government. How does this fit with every single inverse condemnation case we've had? It's been without a condemnation. Doesn't this action just arise from your relationship with Oak Park and the owner of the, I don't understand how this converts itself into an inverse condemnation. So explain that to me.
Justice Rosen, several points in that regard. First, this is exactly what this court specifically noted in the Prairie Center development case. In that case, we had a party who was an aggrieved property right holder. That party was unnamed. That party attempted to intervene. This court held that he could not. And in the last paragraph of that opinion, what this court stated was, if you have an injury, file a claim in inverse condemnation, which is exactly what happened today.
Did you attempt to intervene?
In this case, we did not. And the reason
why didn't you?
Because Kansas law is absolutely clear that the party could not intervene.
It didn't have to do with your lease agreement that said that you weren't entitled to any of the proceeds of a condemnation proceeding as being a lessee?
No, Justice Rosen, if I can go to the contract argument to respond to that, if I may. Under Section 20.02 of the underlying ground lease, the provision states that GFT may recover from the condemning authority, quote, all damages to its business by reason of condemnation in its own name and right, paren, including moving and relocation expenses and business interruption expenses, close paren. The clear and plain language is all damages. This court takes a plain language approach.
Well, was the city a part of that agreement?
Excuse me?
Was the city a part of that agreement?
No, but the argument here is that we would never, but for this agreement, we would have been able to pursue damages under 26.517. The city's position is this bars that normal statutory recovery.
I'm sorry. I wanted to move to a slightly different area once you and Justice Rosen are done. I wanted to ask a slightly different question, and that is, how does this court and not the Court of Appeals have jurisdiction over this issue?
Yeah, the Eminent Domain Procedures Act empowers this court to take direct review in these cases.
this was not an eminent domain case.
Yeah.
This was your self-styled contract case.
Well, your Justice Nuss, Chief Justice Nuss, this is an inverse condemnation action which is governed under an eminent domain procedures, and so it's our position that we can proceed directly in this court.
Okay, well, the Kansas Constitution, Article 3, Section 3 says that we have jurisdiction as a Supreme Court as may be provided by law. So what law is providing us the jurisdiction as opposed to the Court of Appeals, where an appeal typically would be taken from a district court action?
Yes, I understand your question, Chief Justice Nuss, and it's our position because an inverse condemnation would proceed in the same manner as a condemnation case that the Eminent Domain Procedures Act applies, and we have appealed directly to this court.
And what is your best case to support your position?
The plain language of, I believe it's 26504.
But 26504 speaks of when the plaintiff has the power of eminent domain, an action may be brought under that section. And that is not the situation that we are in.
That's true, Justice Lukert. But in this case, since we are proceeding and seek the same recovery that we could get if we were in an eminent domain setting, we're proceeding under that same act.
But you chose not to intervene in that case.
In the condemnation case?
Right.
Well, it wasn't a choice, Chief Justice Nuss. It was this court's opinion, and Bullard directly bars that, and it's exactly the holding that this court's handed down in the Prairie Center development case, where the non-named party attempted to intervene, and this court said it was barred because Chapter 60 does not apply to an eminent domain proceeding. And moreover, this court held in that case, because the aggrieved property right holder had not suffered injury yet, this court held that party lacked standing. And what this court said in the final paragraph of that case was, when you are injured, proceed in an inverse condemnation case. If I could go back to the contractual provision, which was the crux of the district court's opinion below. The district court reads the term including moving and relocation expenses as a cap on damages. That's error. The participle including, in Black's Law Dictionary, page 766, including means a partial list, not a cap. If my wife sends me to the grocery store and she says, get all the groceries, including cookies, I have not violated her instructions when I get bread, milk, and cheese. Yet that's exactly the construction that the district court gave to this contractual provision here today. It took out its red judicial pen and crossed out the word all and wrote in the word only in front of including, turning that into a cap. Yet this court has been consistent. We could look to Wood River Pipeline, for example, that words cannot be written into a contract when they're not there and impart an intent wholly unexpressed in the agreement. That's exactly what happened in this case when the district court read including moving and relocation expenses as a cap upon all damages. That's contrary to the plain meaning of the text. And indeed, the district court in the first volume of the record at page 22 tells us why the district court presumed, as a matter of the district court's economic theory, the district court presumed that the parties would never have decided the case would never have drafted the contract this way. But that, again, is error. That's a classic beyond the four corners of the document approach. The district court presumed a particular worldview, particular economic view, which is not expressed in the agreement. Finally, in the assignment, which is also registered, to which the underlying property holder ratified at section 17B, it states that GFT is, quote, free to make its claims against the condemning party for actual provable damages. The plain text of this agreement makes clear that if GFT can prove, and we believe it's at least a factual question that it can, if GFT can prove damages, it can get them and is not barred under the leases at issue here.
How does that square with the undivided fee rule?
Thank you, Your Honor. The undivided fee rule isn't a great fit in this case, to be sure, insofar as in most cases, all the parties are present. In this case, GFT was not present to present its evidence as to what market value was. It was not present to present those arguments to the appraiser. And because it wasn't present, we will have to ask for a second bite at the apple if you want to look at it that way. But to go the other way in this case would allow any city, either through negligence or purposely, which is not the case here, but through negligence or purpose, to omit a registered property interest holder and say, we had a condemnation proceeding, sorry you weren't there, and what is your recovery? Nothing. That's not how we protect Fifth Amendment rights. The city's approach here is to treat Kansas law, statutory notice requirements, and joinder to the original condemnation proceeding as if they don't really matter. Yet these are statutory commands. They're not statutory suggestions. They're commands in light of the 14th Amendment due process, in particular the Mulaney versus Hanover Bank decision. It's exactly as with Justice Stiegel suggesting in his concurring opinion in the Prairie Development Center case, that these statutory prior notice provisions create a flood wall that protect Kansas citizens against this type of abuse. That's exactly what happened.
How do we deal, on your notice argument, 26503 says, no defect in any notice or in the service thereof shall invalidate any proceedings. How do you read that in light of your position, and especially when you did have notice? One of the parties gave you notice fairly contemporaneous with the filing of the eminent domain. You had notice. So how do we fit that 26503? How does that come into play?
If I can answer that question in two parts, Your Honor. First, we didn't have notice. We did not have our statutorily required notice, leading to the type of issues that Justice Stiegel suggested in his concurring opinion. For example, if we look to that particular notice on the third volume of the record at page 324, the notice, which is not the statutorily required notice, a letter from a third party says, it's our understanding that Firestone's parking will be unaffected by this action. This is exactly why the statute requires the statutorily prescribed notice and not a reliance upon what third parties might present. We did not get our legally required notice. It's not a defect in the notice. It's not an issue of substantial compliance. There was no statutory notice given. The city did not give us notice. Third party forwarded things to us. That's not the type of notice required under the statute.
But you're not arguing you didn't get actual notice.
Well, Your Honor, there's no actual notice provision in the statute.
Well, I understand. But you knew about the condemnation proceedings.
Well, Your Honor, we knew about the condemnation proceedings, and third party informed my client that the parking would not be affected. It's our position as a matter of law that that's about as relevant as the color of my suit. We're required to get our statutorily required notice. We didn't get it. If you had a different statute that said you're on actual notice, it would be a different statutory provision, but that's not the one we have in Kansas. The one we have in Kansas has a prescribed methodology to protect exactly these types of injuries at play.
What we're left with is the city of Lenexa has already paid what the appraiser said this taken property was worth, and now you're asking for them to pay more. Is that correct?
Yes, Chief Justice Nuss, and two issues here. First, GFT was not there. If we had been there, I can't predict a counterfactual, but we could have presented evidence of fair market value. Secondly, any condemning authority in the state of Kansas can easily avoid this by following the statutes, giving parties who have a registered interest their notice, and joining through the condemnation proceeding. So this is not a get-rich-quick scheme, right? Follow the statutes. I believe I'm out of time.
If you had been present and had presented evidence of fair market value, that would have changed the valuation at that time. But that would not be the same as the equivalent of the damages you are now seeking, would it?
Justice Luker, we have not had, that's at least a fact question. We haven't had that trial on the damages below. I believe in order to reverse and remand to this case, we only need to show there's at least $1 at issue, that we could at least be $1 more, and we believe that there is fair market value there. What that ultimate damage would be, what the present values of this, all fact questions for the fact finder below.
But if it was fair market value, wouldn't contractually that have gone back to Oak Park?
No, Justice Luker, it would not. When we look at the text of 20.02, if the claim for damages is to GFT's business in its own name and right, that those damages would flow to GFT.
But the condemnation is seeking the difference in the value of the property.
And-
How is that a business interest of your clients?
In Janssen Trust, the court specifically addressed the question of whether lost business profits are the type of thing that can be factored into fair market value. and this court held that it could. So our position is that lost rents are exactly the type of lost business profits that this court looked at in Janssen Trust, that those profits could have been presented as a measure of fair market value, and that those are exactly the type of damages that would have flowed to GFT and not as a diminishment of the underlying value. Again, that's a fact question. The fact finder would weigh that evidence and believe the two parties, but that's a question of fact.
Do we have any further questions of counsel?
I've got one. I'm sorry, Mr. Orick. I'm still hung up on jurisdiction, and I have to apologize. If we were in Topeka, I'd be able to fool around in the files a little better than I can do from here. In your notice of appeal, did you file directly with this court?
We did, Justice Biles.
Okay. So if we find that you aren't permitted to file in this court, our only option is to dismiss.
I believe that's true, Justice Biles.
Any further questions? Thank you, counsel. We'll see you on rebuttal.
May it please the court, again, I am Tim Orick. I am here for the city of Lenexa, Kansas. With me here today is Mackenzie Harvison. Ms. Harvison is the deputy city attorney, and she is here as the party representative tonight.
Counsel, I wonder if you could start at the beginning based on some of the questions we've posed to your opposing counsel. And the threshold question would be jurisdiction. How does this court have jurisdiction over this, whereas the Court of Appeals may?
I looked at this question pretty hard because I docketed an appeal about 30 days ago in an injunction case that was ancillary to a Chapter 26 administrative action. And when I looked at 2604, that does allow direct appeal to the Supreme Court, it allows direct appeal only for actions arising under the Eminent Domain Procedure Act. And so in that case, and I got to say I was a little surprised because I'd always sort of thought, well, if it relates to eminent domain, you get to go there. Well, no, you only get to go directly to the Supreme Court for cases arising out of Chapter 26501 at SEC. So I would suggest your question is well placed, and I'm not sure that this court does have original jurisdiction in this action.
Assuming if I assume for the purpose of the question that you're correct about the interpretation of that statutory provision, is that a jurisdictional problem? Or is it just a procedural problem with the way the statute was either followed or not followed?
Well, y'all know your rules better than I do, but I would suggest to you that it's jurisdictional.
Well, the follow-up question, I guess, would be, is it conceivable, is it possible that the Court of Appeals could have jurisdiction over a case that the Supreme Court did not have jurisdiction over? Well, we can transfer a case from the Court of Appeals if we want to, on our own motion.
Exactly.
So how could we not have jurisdiction? I understand that may not solve all the problems because there might still be a statutory procedural issue, but
Right.
jurisdictionally,
You know, when I read those rules and it says which cases go to Court of Appeals and which can go to the Supreme Court, it's pretty clear.
well, if it was an actual eminent domain case and someone tried to docket an appeal in the Court of Appeals, it seems to me the argument would be strong that the Court of Appeals does not have jurisdiction. That's different than arguing that the Supreme Court doesn't have jurisdiction where the Court of Appeals does.
Yeah, I believe 26504 says that those actions may be filed in the Supreme Court, not mandatory, but that you can go directly to the Supreme Court if you like. Now, I'll be honest with you, if we find that no jurisdiction here, this should have been filed back in the Court of Appeals, we'll be arguing it in the Court of Appeals someday, and somebody will likely seek petition for review at some point. So,
I take it from that you're not objecting to our jurisdiction. I mean, understanding we have a independent duty to assess our own subject matter jurisdiction. But you're not here saying you don't have jurisdiction.
That wasn't part of our argument, but again, I've read it more than once, that the court on its own motion is required to decide whether it has subject matter jurisdiction or not.
My
Could
only
you
problem-
address,
Sorry.
are you still on jurisdiction? Yeah, go ahead.
My only problem, and I read the statute the way you began your argument, and that the eminent domain authority had to be exercised in order to get a direct appeal here, except there are two cases, one from 2006 and 2007, where a prior Supreme Court took direct appeal of two inverse condemnation cases without really commenting on it, and I don't know what to do with those two.
I don't disagree that those are there.
I mean, I know what
Not
I
every,
want to
not
do,
every
but
case is, not every case going back is correct. And again, maybe those those courts should have raised that issue. I don't know why they didn't, but it's been raised here. Quite frankly, we didn't brief this issue. But again, I think the court does have an obligation to answer it.
If you're done talking about jurisdiction, I wanted to go back to an issue that Justice Rosen raised with opposing counsel, and that is this or is this not an inverse condemnation?
It absolutely is not. And if there's one thought I can leave behind tonight, it's this. This is not an inverse condemnation claim. This is a claim for third-party indemnification under a contract that my client's not a party to. And I don't mind telling you, there is no precedent in this state that there are two bites to the apple out there, because that's what they're claiming. And make no mistake, they are not claiming they're entitled to this second bite at the apple because they were not named. They are very explicit in their brief that their cause of action didn't arise until the Court of Appeals ruled in litigation between the sublessor and the subtenant that they contractually were obligated to make a rent reduction. That's when they say their cause of action accrued. So it is, don't think this case has anything to do with them not being named. It isn't. They think they are arguing that they get another bite of the apple anyway.
What was the first bite at the apple?
The first bite of the apple would be under the undivided fee rule. All the interest holders were awarded the diminution value to the property resulting from the taking as adjudicated in the eminent domain, the administrative eminent domain action. That's the first bite of the apple. But they tell you they chose not to intervene. They're not saying they didn't intervene because they didn't get notice or they didn't know the action was out there.
Did the city also choose not to give them notice?
No, it was a mistake.
Okay.
And we've conceded that all along. They should have been named. But
Why isn't that where we start? That the power of eminent domain is in some sense is a ruthless power of the government, and we ought to start with, did you give the proper notice? And if not, you're sort of behind the eight ball all the way through.
But Justice Stegall, in the Prairie Center development case, this court was very clear that the remedy, if somebody wants to make a claim of statutory defect in the petition, the district court in the administrative eminent domain action has subject matter jurisdiction to consider the claim of a non-party that there's a statutory defect, and the remedy is to void the proceeding. That is as clear as day is what Prairie Center Development tells us. Now, in Prairie Center Development, in that case, there was explicit language in the taking description that established that the easement at issue there was not, it was specifically carved out from the taking, but the court said, had that exclusionary language not been there, the plaintiff in that case would have had a good argument. And again, I was in Prairie Center Development. I know those facts well. And again, it establishes a very clear remedy. You're a non-party, and again, in Prairie Center Development, on behalf of Water One, we challenge the district court's subject matter jurisdiction and this court's subject matter jurisdiction to hear whether or not the proposed intervener in that case had grounds to try to void the action. And the court said, yeah, in most cases, had this happened, this lack of notice, that's your remedy.
They
But-
have to,
but-
they have to seek that remedy before the eminent domain action is completed, though? Is that your position? Or is your position
They
they're
better
just seeking?
seek it sometime. I mean, at some
Okay.
point, you've
So I'm
got to seek
asking-
it. And the point we've raised through this, and I'm sorry,
No, that's
I
okay. Let
didn't
me
mean
just
to
tell you what my
interrupt.
question is so that you can zero in on that. I'm sure you have other worthwhile things to share with me, but let me just ask my question.
Certainly.
So is your position tonight that they're just too late to seek this other remedy, to void the action after the fact?
They've never sought that remedy.
I understand they
They've
haven't.
never pled it.
Is
If
it your
they-
position tonight that they could still do that?
I have said all along, in every level that this case has been adjudicated, that that's the remedy they should be seeking.
Okay.
But they've not, and we know why, because it's a dead end for them. You void the action, okay, we're going to go do it again, and you're going to be at the table, you're still not going to get anything. And that's what the district court found. And if I may,
And they're not going to get anything because of the contract they entered into, or they assume, is that
yeah,
why?
but I mean, they're contending that their cause of action arises out of a private contract.
Right.
There's just no precedent for that creates some kind of an inverse condemnation claim because two parties think of some provision to stick into their agreement.
Let me just ask you
And-
something about just the valuation. And if a sublessee doesn't get notice, how can the appraiser accurately calculate all of the total loss resulting from the condemnation? How does that work?
Because they're
If GFT
applying-
Lenexa didn't get notice, they say they had maybe something they could have or couldn't have. They might not have gotten any compensation as a result of their position. But how is it an accurate fair market value that's given?
Because the court-appointed appraisers are charged with valuing the undivided fee simple interest. They're not valuing the leased fee. They're not valuing the fee simple interest, the leasehold interest, the mortgage interest, some judgment interest. They value everything as if held, the entire bundle of sticks, held by one party. It's elementary to Kansas eminent domain law, the undivided fee rule. That's why we know, and those folks were there, the fee owner, they were awarded $284,000. So they were there. And if I can say this, because I think this is important, because what I'm asking you to do is to make the same ruling that the district court did. It was faced with cross motions for summary judgment. Your standard of review, of course, is unlimited. You decide as a matter of law whether one party or the other was entitled to judgment. That's exactly what the district court did. And what I think what was I think the district court followed exactly what this court said it should do from the Cregan case. And if I can say this without patronizing the author of the Cregan case, I think one of the good things about that case was it took us back to the bundle of sticks argument. Everything starts in real estate with your bundle of sticks. And what the district court said was that the bundle of sticks belonging to the tenant is necessarily circumscribed by the terms of its lease with the fee owner. And under that lease with the fee owner, it gets nothing, always. Now, what they're asking us to do now is to indemnify them because they had a separate contract with the sublessee. And I guess my question would be, how many times might we be liable? What if there is another sublease and another, each with terms that those parties made up between themselves? Is the condemning authority supposed to be liable for all of those indemnifications, all those ripples down the line? Because they happen to make a contract between themselves that defined and entitled the sublessee to the rent reduction. But again, they're not asking for diminution in value to their leasehold interest. What they're asking for is direct dollar for dollar indemnification from their contract liability. There is nothing out there that supports that. This is a claim without any direct precedent in Kansas.
Counsel, your opposing counsel quoted the Jason Trust case.
Yes, sir.
Could you tell us why that helps him or does not help him?
Well, I don't think it helps at all because it says parties are free to contract for anything they want. And contrary to what counsel told you, the lost profits in Jason Trust were not considered because it had some impact on fair market value, but because under that particular sublease, it said sublessee can claim lost profits. And the argument was, well, lost profits is not consistent with eminent domain law, so therefore the subtenant shouldn't be able to claim that. And this court said, rightly, two parties can contract for whatever they want. If they want to include damages that may not be compensable in eminent domain, they can do
It had
that.
nothing to do with the ultimate valuation of the property. It's just the dispute between the parties on how that valuation would be allocated. Is that right?
Correct. In
How-
the
how
first
they divide up
instance,
the
between
bundles.
the fee owner
Right.
and everybody else. And what the district court found was the only sticks that this property owner has are defined by that primary lease. And the primary lease says you get nothing. And that lease might say you can go maintain a cause of action against the condemning authority if you can, but that doesn't mean that trumps state law. And that's what they're asking you to do, is to find that their private contracts trump state law. And again, they could have gotten in on the action, but they said they chose not to do so, not because they didn't know about it, but they didn't think they had a cause of action at that point. They think their cause of action accrued 2 years later after the Court of Appeals ruled on their sublease.
So as far as you're concerned, whether they, even if they didn't have statutory notice, that didn't bar them from intervening under an initial condemnation action?
Certainly not to challenge whether or not there was a statutory defect that would potentially void the proceeding. It also would not prevent them from participating in the 26-517 apportionment hearing that they had actual notice of because the fee owner gave them notice of a 26-517 apportionment hearing. And of course, they didn't contest it because the lease is as clear as could be that they don't get anything. So again, we could void the proceeding, go back and do it again, and maybe the fee owner gets more, maybe they get less. It's kind of a futile act, I think. But again, as the district court found, they've never asked for that. But we know why they haven't, because it doesn't yield them anything. It's a dead end.
Counsel, you're out of time, and we've taken a lot of your time with our questions. Would you like 30 seconds to wrap up and tell us what you want us to do?
Certainly, Judge, or Justice, Chief Judge. Justice. I would. I would like you to sustain the district court's entry of summary judgment in favor of my client. I think the rationale offered by the district court was entirely consistent with Cregan. And as a matter of law, this third-party indemnification claim has got no basis in any kind of precedent that this court has ever made before.
Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
On rebuttal, and the primary argument, the city asks, how many times will parties such as GFT return and ask again and ask again? That's a power that resides with condemning authorities. They can protect themselves each and every time by merely following the statutes, by providing parties with their statutorily required notice and joining them to the condemnation action. Every condemning authority in the state of Kansas can protect itself.
Why not go back and seek to void the proceedings as was suggested? And then get your seat at the table?
Justice Stegall, I don't read the Prairie Center Development case exactly the same way that the city does. I didn't read it as empowering the party to enjoin, and the city reads that as an exception to this court's Bullard opinion, and that's not how we read that case. As I read that case, you had a non-named party who had an easement that was at that time not under a damage or a taking. The court said you can't intervene, you lack standing, and when you have standing in the future, when you have that injury in the future, what did this court state in the final paragraph of its opinion? It said, come back with an inverse condemnation action.
Isn't at least arguably the distinction between the landowner in that case and your client that the determination was made in the prior case that that landowner actually was not statutorily entitled to notice? Whereas here, it seems everyone is in agreement that your client was entitled to notice. Does that distinction make any difference?
I don't think that it does, Justice Stegall, because what we would say, because the city erred, therefore citizens of Kansas will have less relief. That is to stand the world on its head. The city erred here. The city didn't give us our statutory required notice. The city did not name the party, and therefore it's the citizens' fault. With respect, Your Honor, I would disagree. At the end of the day, I think that the city's argument is essence to not accept the Cregan opinion, nor the string of citations that this court provided going back to 1876, where the United States Supreme Court has recognized contractual rights as Fifth Amendment protected property. Exactly the type of confusion that this court discussed of conflating the text of the Eminent Domain Procedures Act with the Fifth Amendment substantive rights to property is exactly the heart of their opinion. This leasehold was a registered leasehold and it's property under the Fifth Amendment. There are no further questions.
There was a point raised by opposing counsel about you were aware of the eminent domain action, even though you did not receive proper legal notice. And there was a reference made that you chose not to do anything about that action because you were waiting to see if a cause of action did arise, and that did not arise until the Bridgestone versus GFT Lenexa case came out against you. Can you describe your reaction to that argument?
Chief Justice Nuss, the GFT in this case chose, the language of the petition, chose not to do something that it's not empowered to do under Kansas law. Kansas law does not empower GFT to have intervened. It's not a legal choice so it chose to follow Kansas law, and it did not intervene. And exactly as this court stated in Prairie Center Development, that when an injury occurred, when it had an injury to constitutionally protected property, as this court noted in Cregan and the United States Supreme Court has held since 1876, it proceeded exactly as this court directed in the last paragraph of the Prairie Center Development case.
You don't even think you had the right to intervene to challenge the sufficiency of the petition, to challenge the fact that you had no place at the table and the case should be dismissed and started all over again so that you did have one?
Judge Goring, that's not how I read the Bullard opinion, nor how to read the Prairie Center Development opinion. At the end of the day, I think the reason, the policy reason this court has directed parties to inverse condemnation is because at this stage, a motion to void after the fact raises an infinite number of questions. Are we going to have restitution for every party? Are we going to cone off the street? Right? How does that even begin to work? We lost another thing in addition to money. What did we lose? We lost a res judicata argument in the case for the rent reduction. There were valuable interests that we could have protected in that matter.
Quick last question for me, at least. Your opposing counsel suggested that had you had a seat at the table at the outset, your client would have been barred from recovering anything due to this provision in the lease. Do you agree with that or disagree?
I disagree, Justice Stiegel. It gets back to our contractual argument. I understand that their reading of the contract is that we get nothing under any circumstances.
Your view would be that you can stand on your own as a possessor of a contractual interest, which is a protected interest under the Fifth Amendment, and you could obtain compensation for that interest. Is that a fair summary?
Yes, Justice Stiegel, and we don't believe the contract bars. I said we are able to collect all damages to our own business interests. That's a fact question. We have to prove that, but that's a matter of fact.
And even though that is just a contract between you and Bridgestone,
Well, the ground lease would be to the fee simple holder.
right? Okay. Any further questions? Thank you, counsel. Thank you. Thank you both for your arguments this evening. Court will take this matter under advisement.